at the time you were taking that appointment?
Yeah. They could be described as subsidiaries. They were totally owned by Social Security.
Okay. They were owned by...
They are totally, wholly owned by Social Security.
Fair enough. They were owned by Social Security at the time you were taking your appointment.
Yes.
And you knew them to be your clients once upon a time.
They were my clients and they remained my clients during the period of the commission.
And in fact, by the time you were taking your appointment letter, Social Security, and which would also extend to those two hotels, were your clients.
Sorry, say that again.
At the time you were taking up your appointment as lead counsel, Social Security was your client. You said yes to that. I'm extending it to the other two companies.
At the time we took up this appointment,
yes,
our retainer with Social Security had been terminated, but they had given us instruction. They had instructed us on various matters, and
yes,
SSC1 was one of them. Now, that doesn't change anything. As regards Ocean Bay and Sun Beach, we were their lawyers as at the time of the commission.
Okay, that's my question.
Yes, but again, it doesn't change anything because we were lawyers for Ocean Bay and Social Security, because Ocean Bay and Sun Beach, because they were owned by Social Security.
Yes.
So the interest of Social Security aligns with the interests of their subsidiaries, obviously, and that is why we were able to represent them. So nothing changes by the fact that they are subsidiaries. In other words, that's what I want to say.
Okay, thank you. So they were subsidiaries of Social Security at the time, and you were representing all three institutions, correct? So that is Social Security and the two hotels.
We were representing the two hotel companies. We were their lawyers. We never ceased to be their lawyers. As I said, for Social Security, our retainer was terminated in around 2010, and then in 2017, Social Security started giving us work again. Yes, so we were representing Social Securities in certain matters. Yes.
Council, please can we stand down for 5 minutes? I'll be back.
That's fine.
Because we don't have quorum yet. Yeah. All right. Thank you. We resume. Council, you can proceed.
Thank you, Honorable Chair. Ms. Bensouda, I know it was a short break, but I'm obliged to just remind you that you're on oath. Before the break, the point of discussion was your retainership with 2 companies and your engagement with Social Security. And I had asked that at the time, or you had made clear that at the time you were offered the position of lead counsel, you were acting for Social Security, even though, to be fair to you, your answer was that in a limited capacity and in the same interest with the government, and you were also retained by its 2 subsidiaries. Now, my question would be, looking at MOJ2, wouldn't it be apparent, looking at the mandate of the Commission, that it was inevitable that your 2 retained clients would be looked into and automatically a conflict would have arisen? And also that you were representing Social Security in a matter where you were recovering funds for them, and that would also be a conflict. Wasn't that apparent?
There is no conflict, as I said, with my representing Social Security or its subsidiaries in any capacity whatsoever. There would be a conflict where, which would be a conflict relating to perhaps subject matter, because conflict comes in various ways. If I had represented Social Security in a transaction with former President Jammeh, for instance, in as much as there would be no apparent conflict, but in relation to that transaction, relation to that transaction, it is better I recuse myself because I may not be independent since I dealt with that transaction. So it's possible that I'm not conflicted as far as Social Security is concerned, but when it came to a particular transaction with President Jammeh, I was involved, and therefore I should recuse myself from that investigating that transaction. But as I said, happily, I knew as a fact when I had my discussion with the Attorney General, and it was one of the first things, that I had never in any way represented knowingly former President Jammeh or his family members or any of his companies, never. So that was the main question of conflict. Once that was resolved, there was nothing else to resolve. Nothing. Even if I had representing Social Security to sue the president or his companies, that's not conflict. I'm still representing Social Security's interests. So I can represent Social Security's interest in any form, directly or indirectly. I can represent government insofar as Social Security is concerned in any form, directly or indirectly. All those interests are aligned. They are all public. So no apparent conflicts could arise. However, during the course of investigation, possible, because this is a big investigation. We investigate so many parastatals, so many transactions. So it's possible we come across transactions in which I was involved, and in that case, I cannot investigate those transactions. And it happened that we came across transactions I could not independently be seen to be investigated. And that's why another lawyer was taken. So conflict was not an issue. As I said, Mr. Chairman, conflict is a threshold issue for all lawyers. Every day a new client comes and wants you to do something. The first thing you are obliged to do is do what we call a conflict check. Are you able to take this work? You have to check that. Is there anything relating to this matter which prevents me from taking it? If he's my relative, if the person you want me to sue is my relative, obviously, close relative at that. But it's even possible that I represented him, but in something that is so irrelevant that you, the client, it's the client for the client to decide that I'm comfortable. Please, you can go ahead and take my case. You have explained, but I'm happy for you to do my case. So I had a discussion with the minister, it was the client, and we discussed possibility of conflict. We agreed that there was no apparent conflict. If I had not represented Jammeh in any way, there was no apparent conflict. However, if conflict should arise in any matter, I would recuse myself. And that is what happened.
I would move on from the point of conflict and move on to the commencement after you had just been appointed. But before I do, Ms. Ben, I would like to tap into your experience in public service. You see, one of the key considerations government is saddled with is public interest and public perception. And especially the latter, public perception, where I would like to know whether that was a consideration for you before you took on this job, because you clearly had dealings with some of the subjects, some of what would be the subjects of the commission. Now, wasn't it important at the time for both you and the ministry to safeguard that public image, to say, since you had dealings with them, perhaps you are not the best person to take up the role of lead counsel?
I don't understand the question, to be honest. And the question is nuanced, and I don't quite understand what you're getting at. As I said, it's like...
Since you don't understand, I can come back and ask it.
You can, yes.
Right. Public perception is chief amongst the considerations, or should have been chief amongst the considerations when government is appointing officials such as yourself in 2017. Would you agree with me on that?
Public perception has never been a consideration. Perhaps it might be, but in my experience, public perception has never been a consideration when I accept or do not accept any engagement with any public body or enterprise.
And my question was not that it was your consideration, but for the government. And before I asked my question, I did say I would like to tap into your experience in public service. And I would ask the question again, that public perception is or ought to have been a criteria or a consideration in 2017 when appointing officials such as yourself. Would you agree?
I don't think it's a yes or no answer. I was not in government at that time. Perhaps the considerations that will exercise the mind of the Attorney General may be different from the considerations that will exercise my mind as a private legal practitioner. Perhaps this is a question that's better answered by the Attorney General, to be honest.
That's a fair answer. I would give you that. That's a fair answer. And perhaps I would put it from the perspective of the committee that public perception should have been a key consideration, because the buy-in of the public was a crucial factor in transition, is a crucial factor in transitional justice, the trust of the public. And here we are. The government has appointed a lead counsel whose the managing director of a firm that took a receiver, the receiver that was appointed by the government, to court during the same period. Now, from the lens of a public servant or the citizenry, this could be seen as a conflict. Would you not agree? Technical, please. IT, if we can make sure that the witness's mic is in order and avoid further delays.
Hypothetics. The commission of inquiry is over, it's done. The commission has carried out its work. I carried out the work for which I was engaged. The commission concluded, submitted its reports, its functus. So perceptions after, with due respect, 6 years afterwards, is certainly, to my mind, not important. What is important is that from the time I was appointed and for the 18 months the commission sat, no subject of investigation, of all the witnesses we call, of all the close associates that were declared, of all the persons that went to court to challenge the commission, not a single one of them raised the issue of conflict. Conflict is real. If any of them felt that I was conflicted in any manner that was prejudicial to the work the commission was doing, they ought to have raised it. They would have raised it. Because so many people were affected, adverse findings were made against many people, but not a single person who was the subject matter of investigation raised the issue of conflict. Conflict was raised, unfortunately, by the secretary. And he raised it at a time.
We'll get to that, yes.
Sorry, let me answer my question. So we're talking about perception. Apart from the secretary, not a single person raised the issue of conflict. So perception cannot be in hindsight. Perception has to be real and it has to be contemporaneous. At no time during the period of the commission did anything from the public, anything emanate, any concern emanate from the public or from any person who was the subject of investigation of my role or my competence or my capacity to be lead counsel of the commission. So the question of perception is academic with respect.
And with respect, Ms. Bensouda, I would contend with you. I would seriously disagree with you on that. Although I would state unequivocally that myself and this committee, neither myself nor this committee, is questioning your role, your competence, or your professionalism, now or even at the time. But I would say that perception, even if it comes a decade after, matters. Public perception. Because this is an endeavor of government. This is an initiative government had put in place not only to recover monies that were misappropriated during a 22-year regime, but also to restore public confidence in a system, to ensure that the public are aware of all the anomalies that occurred within that 22-year regime. Now, if that process is tainted in any shape or form, even if it's 10 years after, I would contend that that is a key consideration, and that needs to be at the back of the mind of cabinet, especially when it's setting up such institutions. You see, I say this not in vain, but because we're sitting in the National Assembly, a committee of a National Assembly, I would direct your mind to section 102E of the Constitution. And 102E, if I may read, for the record, states, in addition to the other powers conferred on the National Assembly by this Constitution or any other law, the National Assembly may advise the President on any matter which lies within his or her responsibility. Now, sometime this year, there was uproar in the public domain. It has come nearly a decade after the Jammeh Commission had been functus. But the considerations have morphed into the setting up of this here committee rather. And all in a plight to restore confidence of the public in the processes, operations of the Jammeh Commission. And might I add that the interests are the same. So in all respects, the committee's interests and your interests, Ms. Bensouda, are one in the same. I can assure you that. But I will contend with you that public perception does not matter if it comes after the fact. The Commission should have the ability to stand the test of time. I would allow you to react if you wish to, and move on to another point.
Thank you. I think I'm trying to understand or grapple with what you're saying, and I'm giving it some serious thought. On the one hand, I'm being told that my competence or my role is not being questioned. On the other hand, your use of the word stint suggests that my integrity is being questioned. And conflict is a matter of integrity.
Can we give context to the manner in which I use the word taint?
Anything that might have tainted the process.
Thank
That's
you.
what you said.
Thank you.
And if I, in my capacity as lead counsel, was conflicted, in other words, if I, in my capacity as lead counsel, was conflicted with regard to part of the investigations of the Commission, then those investigations would be tainted. And that questions, that word goes to my integrity. I have no objection. Certainly, I can be questioned and my integrity can be questioned. There's no doubt about that. But as a professional, let me say this, that perception can be real, but it can be manufactured. And in this case, all the issues surrounding conflict were manufactured. The source of all the issues relating, all the allegations about conflict can be traced to only one person, and one person only. So I'm glad you said you will come to that, meaning I suppose you come to investigate the circumstances of the raising of the issue of conflict. But conflict is manufactured when it is not real, when it is not made in good faith, and when it is being used as a tool to exploit a certain situation. Because the circumstances in which the issue of conflict was raised is questionable, and we'll come to that. And as I said, those who stood to be harmed by the actions of the former president that were investigated, and those against whom adverse findings were made, were the people who were commissioned. But no one challenged it, except no one raised the issue of conflict, except one person. And as I said, any public perception that arises from the fact that an allegation of conflict of interest was raised is manufactured. So as my answer is yes, public perception can be important and should be important to every public institution. And certainly, if it's within the mandate of this committee, they can probe into those issues. But as I behave in keeping with my integrity, as a lawyer of some over 30 years standing at the time, now I am, of course, 42 years standing at the bar, I will not sacrifice my integrity and my reputation for one assignment. That is not possible. So I have nothing to account for. As far as I'm concerned, I did my work professionally, no conflict of interest arose, and I dealt with every person that appeared before the commission with respect and fairly, and I advised to the best of my ability. The issue of conflict, as I said, is manufactured by a person who has an agenda which he has pursued. And I must, of course, put on record that I'm in court with this person, that's Mr. Kuran. We are already in court, and these are some of the allegations that he's still relying on, raised in his defense. But I do not have any problem. I'll put it out there for the record. So I do not have any problems discussing those issues. But I think it is necessary that the committee is aware. Thank you.
Thank you for that response, Ms. Bensouda. I wished to move on. However, I am obliged to just deal with one more point, the issue of conflict during the appointment, and that is your appearance in court. You had appeared in court in the matter just commenced by the government against the former president. Isn't that so?
No. I never appeared in the High Court in the case of the former president.
Secretariat, if you could assist to show the witness. Honorable Chair, I'll have some difficulty referencing this document because it's from the High Court, and we haven't exactly marked the document, but I would have the document given to the chair before it's given to the witness for the panel to peruse before.